My name is Darryl Allen. I'm a PI and clinical negligence silk at Farris Building. I rejoined Farris Building the second half last year, having been a pupil and junior tenant at Farris before I moved to Manchester in 2000. And as I say, coming back to Farris Building as a silk last year. I'm going to give you a talk today on Swift and Carpenter, the now famous case on the assessment of damages for accommodation claims. And my knowledge and understanding of Swift, I think, is reasonably good because I represented the Personal Injuries Bar Association, which was the only permitted intervener in Swift. I'm going to use slides today. And they'll come up on screen shortly. Don't worry about trying to jot down every bit of detail from the slides because Kelly at Farris will be sending out the slides tomorrow alongside with a recording of the webinar. So you don't need to contact her, she'll send those out to you. In terms of questions, some or many of you may have questions. What we'd like you to do is to make use of the Q&A facility, which means you can type questions as we go, and my preference will be to deal with those questions at the end rather than try and pick them off as I go. If I get through my content, then I can work my way through the Q&A and pick things up for you. And if there's a time limit or you want to ask any further questions, you can email me. My email address will be available at the end. So if I share my slides. Swift and Carpenter. Let's start with the facts of Charlotte Swift's case. Charlotte Swift was age 39 when she was in a road traffic accident, October of 2013. Sadly, the defendant driver was her partner, Mr. Carpenter, and she suffered a below-knee amputation, which left her with severe phantom limb pains. She also suffered on the other leg a serious injury to her right foot, leaving her with significant ongoing pain and stiffness. She was significantly disabled. There was no dispute that her current property was unsuitable for her needs and that she required a property which was large enough to be adapted to accommodate her disability with some degree of wheelchair usage, but also storage for her prosthetics, wheelchairs, and other equipment. What was peculiar about Charlotte Swift's case and its impact upon the numbers was that she lived in West London and the value of her existing property was £1.45 million. Bungalows in that area are as rare as hen's teeth, and so what the judge found was required, and that was Mrs. Justice Lambert, she held that Mrs. Swift required a two-storey property which could incorporate a through-floor lift and had space for adaptation and additional space, which would cost on her findings £2.35 million. That meant that there was a capital shortfall of £900,000, but because Mrs. Justice Lambert held that she was bound by Roberts and Johnston, tied to a negative discount rate, the award for the cost or the additional cost of funding that increased accommodation need was nil. But the judge herself gave readily permission to appeal because, as we've all known, ever since the introduction of the negative discount rate, if not before, Roberts and Johnston was not, it would seem, working in the way that it was intended. In the interest of time, I'm going to take it as a given that you are familiar with what the law was before. And so this is just a gentle but brief reminder. Under the old law, the cases of George and Pinnock and Roberts and Johnston, the Court of Appeal held that the claimant was not entitled to the additional capital cost of the property because that would mean that he or she was left with an asset an asset which probably increased in value over time, house price inflation in the 80s and into the 90s being confidently predicted to go up at a rate at least matching inflation. And if you gave the claimant the full capital cost of the property, that would mean that the estate of the claimant on death would benefit from what was and is now consistently referred to as the windfall. Instead, what the court said was, well, a claimant in those circumstances, in fact, purchases the property using other capital from the compensation award. So what the claimant or the plaintiff, as he or she then was, has lost is the loss of use of that capital and the loss of investment return that the claimant would have enjoyed from that over time. They had had to give up some of their award and tie it up in capital, in property. They hadn't actually lost the money, it was still there, but it was tied up in bricks and mortar, which meant the claimant wasn't getting the capital return they would have got. So Roberts and Johnston said that's the nature of the loss, and the measure of the loss is a 2% per annum. That was the old calculation. In Wells and Wells, the case, the House of Lords case on the discount rate before the Damages Act, where the rate was set at 4.5%, 3%. One of the appeals, Thomas and Brighton Health Authority, had an issue about the Roberts and Johnston calculation. It was agreed between those parties in the Thomas appeal that Roberts and Johnston methodology applied. The debate between the parties was simply what rate to use. Was it the 2% rate, as in Roberts and Johnston, or should it be substituted for the discount rate? And if so, what rate? That's important because it was argued in Swift that the Court of Appeal was bound by Wells and bound by Thomas to apply a discount rate Roberts and Johnston calculation. But as the Court of Appeal emphasised, there was no issue about the Roberts and Johnston methodology. It was not considered at all. The only question was what rate to put in that calculation, where the parties agreed the calculation was appropriate. So that's the history. That means that in two cases on accommodation, one in 2017, the case of JR, and in 2018, the case of Swift, two first instance judges, Mr. Justice William Davis and Mrs. Justice Lambert, both held that they were bound by Roberts and Johnston. They were bound to apply the formula, and that was bound to produce a nil award for the claimant. And so it's against that backdrop that Mrs. Justice Lambert gave permission to appeal, and we had the appeal before the Court of Appeal. For any of you who have set about or completed reading the judgment, it's an unusual judgment because it was an unusual appeal hearing. We heard, or the Court of Appeal heard, oral evidence from a number of financial experts, none of whom had reported or given evidence at the first instance hearing. That was all evidence that was provided and adduced for the first time for the Court of Appeal. And it was a 3-day appeal hearing, divided the first day and a half to the evidence, the second day and a half to the submissions. And the questions that the Court of Appeal set itself to answer were, first of all, was it bound to follow Roberts and Johnston? And that broke down into 3 sub-questions. One, did Roberts and Johnston apply to the facts? Second of all, if it did apply, was the court prevented from revisiting Roberts and Johnston? And if the answer to that question was no, if it could revisit Roberts and Johnston, should it revisit Roberts and Johnston? The answers to those questions were, yes, it did apply. This was a factual situation in which the claimant had a need for a purchased property. So Robertson Johnson on its face was applicable. On the second question, was the court bound to follow it and could not revisit it? The answer was no. The Court of Appeal held that Robertson Johnson didn't establish binding legal principle. What it established was a methodology, that the calculation was authoritative guidance given by reference to the economic conditions of the time, which was designed to achieve the fundamental legal principle of fair and reasonable full compensation for an injured claimant. That was the principle that Robertson Johnson, like any other key case on the question of damages, is anchored to, producing an award of fair and reasonable compensation, but it was no more than authoritative guidance and a methodology. So at stage 3, should the court revisit Robertson Johnson? The answer, as you'll all have seen from what's been circulated about Swift, was yes. The reason was, not only was it authoritative guidance, which could be revisited, but Robertson Johnson, applied to Mrs. Swift's case, produced a nil award, where she undoubtedly had a need for, an injury-related need, for a property at a cost of an additional £900,000 to her. A formula that produces a nil award of compensation in those circumstances does not deliver fair and reasonable compensation and was no longer fit for purpose. Therefore, answering the questions in that way, the Court of Appeal held it should revisit Robertson Johnson, which meant it had to consider what alternatives, if any, were there, which would enable the courts to compensate a severely injured claimant such as Mrs. Swift. So there was a search for a workable alternative, and that's where all of the financial experts came into the case. It's probably worth identifying those alternatives that were not available in Mrs. Swift's case. It was agreed between the parties that the following were not available. 1, an interest-only mortgage backed by a PPO. 2, a lump sum award based upon a multiplicand approach, with either mortgage payments or mortgage interest payments or rental costs. 3rd, an alternative that wasn't available was effectively a loan from the defendant to the claimant, with the defendant having a charge over the property. And it's just worthwhile clarifying why those weren't available, because there may be other cases on different facts with different circumstances where we might need to consider revisiting those options. The appellant and respondent had expert evidence from mortgage experts. What they said was lenders, mortgage lenders, would not regard a periodical payments order as a sufficiently secure source of income for the purpose of mortgage lending. Whereas earnings are, self-employed earnings are, some forms of investment return are, and other payments such as financial payments pursuant to a separation or divorce arrangement may be, a periodical payments order would not be considered to be secure, and therefore you couldn't lend against a PPO. If you can't lend against a PPO, then ordinary lending based upon multiply and multiplicand, there was no evidence that Mrs. Swift could or would be able to get a mortgage for the £900,000 that she wanted. There had been a illustrative mortgage offer that was produced by the appellants, but that was abandoned, and the expert said she wouldn't be able to get one. So that's why 1 and 2 fell away. But there may be cases where somebody has an intact earning capacity who might be able to secure a mortgage, and query depending upon the facts and circumstances, whether they might or might need to look at that as a basis for a claim. But in Swift, it didn't arise. Similarly, the loan or the payment of damages to purchase the property, that then the claimant grants a charge back to the insurer, as a matter of corporate structure and regulation, the insurer couldn't commit to such an arrangement. My own experience is that's not unique to that insurer. That is a problem for many, if not all. So that one probably is off the table. And in any event, the court probably doesn't have jurisdiction to make an award on that basis, unless you say there's some sort of undertaking given by the claimant, but that's a discussion for another day. So those were off the table. And in Swift, at the Court of Appeal stage, it was common ground that if the court was satisfied that it could revisit Roberts and Johnston, and if it was satisfied that Mrs. Swift suffered a loss for which she was entitled to compensation, then the appropriate model to adopt was one based upon a reversionary interest. And if you follow this on social media or on websites, or you've probably been sent bulletins by FARAs or by others, you'll have seen reference to reversionary interest. So the model that was adopted in Swift was agreed between the parties to be in principle the correct model if we got to that stage. The question was, how do you value the reversionary interest and how do you produce an award of compensation? So it's probably right just to explain to you a little bit about what a reversionary interest is. That's not because, as personal injury common lawyers, we now have to understand the finer details of chancery or land law or trust law. It's because if we understand what the concept is, how we now value accommodation claims makes a lot more sense and is easy to follow. So reversionary interest. You see the name there, Brian Watson. Brian Watson was the expert that we called to give evidence on how you value reversionary interests. And I'll say a little bit about him before we go on, because every case has its little side story. If when you read the Swift judgment and you see the name Brian Watson, and we are debating how actuarially you value a reversionary interest and how that translates into a personal injury claim, and we're talking economics and economic forecasting and so on and so forth, you might be drawn to think that this is some city wizard in a sharp pinstripe suit who is advising huge corporate clients on actuarial models to value assets, pension funds, or the like. Nothing could be further from the truth. Brian Watson is a delightful individual who gave his time and his experience and his expertise for free. He acted pro bono throughout. He is up in Yorkshire. He has spent his career specialising in the niche area of selling financial rights and interests. He is in the later stages of his career and probably was contemplating selling or winding down his business and his consultancy when he got a call from us asking if he'd get involved in this case. He gave his evidence sat on his sofa at home in Yorkshire. He was very relaxed. He was the least medico-legal savvy of all of the experts because he'd never produced a Part 35 report and he'd never given evidence. But his evidence was the most important on the model that we now adopt for assessing compensation for this claim in these cases. So, what is a reversionary interest? The best illustration is this. Mr. and Mrs. X, married couple, own a house. They both prepare wills in which they specify that upon their death, whoever dies first, their share of the property passes to their surviving spouse, and upon the death of the surviving spouse, the ownership of the property passes to their children. So statistically, Mr. X is likely to die first. Mr. X dies and the house passes to his wife. She lives in that house. She has the right of occupation and ownership of the house for the remainder of her lifetime. But upon her death, ownership passes to the grown-up children. So upon Mr. X's death, Mrs. X becomes the life tenant of the property. She has the life interest, i.e., the right of ownership of that property for her lifetime. The children, are what used to be called the remaindermen, they own the reversionary interest. Upon Mrs. X's death, ownership will revert to them. So in that little illustration there, the life interest is that enjoyed by Mrs. X all the way up until her death. At the point of death, the reversionary interest passes to the grown-up children, and then they have ownership of the house. Why is that of any relevance or importance to what we do, you might ask? Well, it came from a suggestion by Stephen Irwin at the very first adjourned appeal hearing, which is, if you say what Mrs. Swift needs is a larger property for her lifetime, because upon death, she doesn't need the house anymore, the larger house. Her compensation bank balance should be at 0 at that point. Then really, you might say that she's a life tenant. She needs the life tenancy of that larger property. And what Stephen Irwin knew that we didn't know at that stage was that there exists a market for reversionary interests, that they are sold. And they're sold through Brian Watson's auction business and consultancy. Because you can well imagine a situation in which the grown-up children in my example perhaps are due to receive ownership of the £500,000 house. They've got that right, that entitlement, but they might have to wait 15, 20, 25 years to access it. And they might want or need to get their hands on some money now. And therefore that reversionary interest has a value. They could sell it to an investor. There are a small number of individual investors who purchase these reversionary interests on the basis of, well, they can buy it now. Let's say it's the £500,000 house. If they buy the children's reversionary interest for, let's say, 100,000, and it's expected that Mrs. X is going to die in 10 or 15 years' time, then at that point, they'll get their hands on a £500,000 house, plus whatever increase in value it has enjoyed as a result of house price inflation. That is quite good business if you buy at the right price and you get your hands on the asset at the right point. So there is a market in these reversionary interests. Why is that of relevance? Well, come back to the problem in Roberts and Johnston. The problem in Roberts and Johnston was the windfall. If you say that the windfall is what passes to the estate on the claimant's death, that equates to the reversionary interest. If you can value the reversionary interest, then you can put a value on the windfall. And if you can value the windfall and remove it from the award of compensation, then you get to the point of compensating Mrs. Swift for what she needs, the cost of having a property for life, and you are not providing a windfall, because if you've deducted the value of what would pass to the estate from the award, then there is no windfall. There is no overcompensation. Mrs. Swift simply receives what she requires, effectively, to purchase the life interest, as it were. That is the model. So when you're looking at these things, the reversionary interest, or valuing it, is an attempt to put a value on the windfall. And if you can value the windfall and remove it from the award, you don't offend the principle or the mischief that was the real concern in Robertson Johnston. So with that whistle-stop lesson on why a reversionary interest is important and how it works, the court was given 3 options as to how we could value the reversionary interest. 1, the market value. What would a third-party investor be prepared to pay to buy this on an open sale? 2, an alternative, a fair and reasonable valuation based upon rental yield. That was Brian Watson's alternative, and fair and reasonable is a concept well known to actuaries and financial advisors when you're looking to put a valuation on something without a market value. The third, offered by the respondent's expert, was a fair and reasonable valuation based upon what investment returns you would get if you put the capital into shares and bonds. I don't have time, and I don't want to complicate the talk by taking you uphill and down dale on the alternatives, because the court decided that the correct approach was market value. And what they said was the market value of a reversionary interest in this case and the majority of personal injury cases represents the current value of a long-term and uncertain investment. And Stephen Irwin added, it seems to me rather obvious that since the central problem is the current value of a future interest in the property, the best measure of the value is what people will pay to acquire it. So they held that if you're looking to value the reversionary interest, therefore what would otherwise be the windfall, it's the market value. How do you work out the market value? Well, Brian Watson's evidence was that where people, in his experience, are buying these reversionary interests, they're paying about 6.2 to 7%. But that was based upon, as he readily accepted, a small market with a small number of transactions, which has shrunk over time. So it is not a large, deep, robust market. It is a modest one. And with that information and lots of other evidence, the court said, well, we want to set a guideline rate. We want a rate that can be adopted and applied in all of these cases, but we need to be cautious, bearing in mind, 1, the size of the market that Watson's evidence is based upon. Second of all, the limitations on selling these interests in that market. And third, the other factors from the other expert evidence that might suggest a lower percentage was required. Taking all of that into account, they concluded that 5% was the appropriate rate. Now, pausing there, what does that mean? What's the 5% relevant to? What it means is that when we're valuing the reversionary interest, somebody buying that would want to get a 5% annual return on their investment. So if I wanted to work out how much I would be prepared to pay to purchase this reversionary interest, let's say in the £500,000 house, if I'm going to get my hands on £500,000 in 15 years' time, how much would I be prepared to pay so that I would get a compound rate of return of 5% every year? So by the time I get my £500,000 asset, that's the profit that I've made. That's the annual rate of return I would want to see on my investment. So that's the swift approach that you, and we'll come to the formula, but you work out how much does the claimant need, how much capital do they need in order to fund the purchase, and once you've worked that out, what would be the value of the notional reversionary interest if that was sold? You work that out using the 5% rate, and then you can work out the compensation award from deducting one from the other. But the scope of the guidance, there's no suggestion that SWIFT represents an absolute or rigid one-size-fits-all approach. Stephen Irwin said that they accepted the submission of the intervener, brackets me, close brackets, that this guidance should not be regarded as a straitjacket to be applied universally and rigidly. There may be cases where this guidance is inappropriate. And then this is my emphasis, but a very important sentence. For longer lives during conditions of negative or low positive discount rates and subject to particular circumstances, this guidance should be regarded as enduring. So if you have a, quote, longer life expectancy case and you are in a negative or low positive discount rate phase, we're now in a negative discount rate phase, subject to any particular circumstances, the SWIFT approach applies. What they recognised it doesn't necessarily apply to, because different considerations could apply, and they express no view on that at all, is short life expectancy cases. And that's been quite a hot topic that people have been asking questions on that I'll come to. But it's plain in the judgments of Irwin and Lord Justice Underhill that the SWIFT model does not apply to short life expectancy cases. So in terms of the status of the judgment, it's a Court of Appeal decision. It is binding on all of us until such time as it's overturned or varied. The defendant has asked for permission from the Court of Appeal to appeal to the Supreme Court. The Court of Appeal is going to decide that application on or after the 23rd of October. So that's on or after Friday, I think. There are three elements to the grounds. One, that they were wrong to depart from Robertson Johnston. They were bound by it. Two, they were wrong to reject the defendant's cash flow analysis. And three, they were wrong to suggest a market value approach and the 5% figure they inserted. Whether they get that, we will have to wait and see. The appellant obviously opposes it. I've not seen their response yet that went in this morning. It's yet to be forwarded to me. So we will watch this space on the Supreme Court. So that's the history and that's the issues, and that hopefully gives you an understanding of what was being debated and why. We get now to the practical bits and the things that are perhaps of greater day-to-day value to you as you navigate your way through your cases. Let's start with the formula. If you've looked at the judgment, you will have seen the conspicuous absence of a formula or calculation of how Mrs. Swift's award was calculated. We asked the Court of Appeal when we had the draft judgment to include something there. The response was that it could be something could be included if agreed between the parties, but absent agreement, they weren't prepared to include something. For reasons I don't need or want to go into, we've not been able to agree a formula, and so that's why there isn't something in the judgment. But Richard Whitehall, who did the case with me, and I are confident that this is an accurate reflection of how you calculate, one, the value of the reversionary interest, and two, the damages award. So R is the reversionary interest. The reversionary interest is, take the capital sum that's required, so what the cost of the property the claimant now needs, less the value of the but-for property, that's P minus V. And then to calculate the value of the reversionary interest, that's multiplied by 1.05. The 5 is the 5%, that's the investment return we talked about earlier, to the negative power of the life expectancy. Don't ask me to explain that to you mathematically. All you need to know is effectively what you're doing is working out what the current value is today of that shortfall in L years' time. It's effectively discount for accelerated receipt. So once you've worked out the value of the reversionary interest using that formula, your damages award is the shortfall. So what's the capital shortfall? P minus B minus R, less the reversionary interest value. Effectively, to remind you, you're taking the windfall element out. So what's the capital that the claimant leads, less the windfall, less the value of the reversionary interest. But let's look at how that works in Charlotte Swift's case, because that starts to translate those letters into actual numbers. You'll remember that she needed a property worth 2.35 million. The value of the property she lived in was 1.45 million. So that's your P and your B. Her life expectancy, not the life multiplier, but her life expectancy in number of years was 45.43. So to value the reversionary interest, it's the capital shortfall, the 900,000, times by 1.05 to the minus 45.43, which gives you a reversionary interest if Charlotte Swift sold that £900,000 property asset to somebody looking for a 5% rate of return, they'd be prepared to pay just over 98,000. If she gives credit for that, it's the capital shortfall, take away the value of the reversionary interest, gives a damages award of 801913. I can be confident that the formula we've set out is accurate for two reasons. One, that's exactly how Brian Watson values the reversionary interest. All that we changed was the 1.05 in the calculation. Second of all, that's the calculation that produces precisely the damages award in Charlotte Swift's case. Those are the numbers that the Court of Appeal found in light of Watson's evidence and the calculation. Now, that's Charlotte Swift's case, but hers was as perfect a exam question as you could get. She had already had a property which you could value. She had an immediate need for a property purchase, which would last for her entire lifetime, that would end upon her death, and there was no betterment. All of the complications we have in our cases were missing. So it's as simple as they come. Let's have a look at some examples of where the calculation might be slightly more challenging. Let's think about a child brain injury case. The claimant's 10 at the date of injury, 20 by the date of trial, has a life expectancy to age 50, so another 30 years. Now needs a £750,000 property. Absent his injuries, he would have bought a family home at 35 with joint ownership, so a 50-50 share. His share or his contribution would have been 150,000. So that's the not unusual scenario. How do we calculate it? Well, there's going to probably be some argument between claimants and defendants about which calculation you adopt. If you do a simple, straight, single calculation using the Swift formula and say, well, claimant now needs 750, would have spent 150, that gives you 750 minus 150, that's the 600. Multiply that by 1.05 to the minus 30, that's the life expectancy. That gives you the value of the reversionary interest. If you deduct that from the 600,000, that would give you an award of 461,000 odd. Okay, that on its face works. If you add that figure to what the claimant would realise if they sold the reversionary interest, plus what he would have put into his but-for property, he has the 750 he needs, and then he can buy the property to meet his disability requirements for the rest of his life. But somebody might say, well, that involves the claimant giving credit for the 150,000 for the entire period, but in the factual scenario, he wouldn't have spent that money for another 15 years. So is there an alternative of doing a split calculation, breaking those two periods into two and doing separate calculations for each period, a bit like what we would have done under Roberts and Johnston? So if you do that, you might say, well, the first period, the reversionary interest is 750 less 0, he wouldn't have spent on a property, times by 1.05 to the minus 15, that gives you the reversionary interest value for that first period. And then you might say you do a second calculation for the second period, bringing into account the 150,000 that the claimant would have spent in any event. Okay, that gives you that value. And then deduct those two from the capital shortfall, the 600,000. What does that produce? Well, the problem with that is it gives you a minus figure. And it wouldn't take much careful thought to be able to say that must be wrong. To say that somebody needs an extra £600,000 towards a house and have a negative award can't be right. So is the alternative then to say, well, that's because you're deducting two reversionary interests from one capital shortfall. Do you need to do two separate calculations? 750 minus the 360, part one, 600 minus the 288 at part two, to give you an overall award of 700,000. Well, I think instinctively one would all say that doesn't seem right, because if the claimant combines the 700,000 with the 150, he's now got 850,000, which is more than he needs to buy the property. For me, I think the flaws in both of those approaches are, it reflects the sale of two reversionary interests or two purchases. The claimant isn't going to sell two reversionary interests in this model. He's only got one property and one reversionary interest. So to make two separate calculations overstates the value of the reversionary interest. There's only one and it only gets sold once. Similarly, the claimant isn't going to buy the property twice. He's not going to buy property at year 0 for 750 and then buy the property at year 15 for 600. There aren't two purchases, just as there aren't two sales of a reversionary interest. So subject to arguing it in an individual case, the split calculation for me doesn't work. An alternative, which might carry greater attraction, is what I've called a weighted calculation. By that, what one approach might be to do two separate calculations. One, with the claimant putting nothing in to the purchase, 0, and working out what the value of the reversionary interest and the damages award would be there. Then doing a separate calculation of, well, what if the claimant puts in 150,000? What would be the value of the reversionary interest and the damages award there, taking 30 years for both. So R1, 0 for the but-for property, minus 30, the life expectancy gives you that damages award. R2 and D2, for the Star Wars fans, investing the 150,000 he would have spent in any event, working out the value of the reversionary interest and the damages award. Then what you could do with that is do a weighted calculation. So on this example, each one is 15 out of 30 years. So you multiply the first figure by 15 over 30, and then the second figure by 15 over 30 to give a weighting according for how much of the period it would occupy, which gets you to 518,821. My slight difficulty with that is, and I'm yet to speak to the actuaries about this, is if the claimant sells the reversionary interest, let's say in the 600,000, giving credit for the 150, then what he would get is that 138,000. If you add 138,000 to the 518, in rough and ready terms, you're getting to about 660,000. If that claimant then puts in his 150, he's then at 810,000. So he's actually got more than he needs to meet his lifetime needs. If that's right, query whether that brings you back to the single simple calculation. Because when you add those figures together, 461 plus the reversionary interest if the claimant sold it, plus the amount he would have spent in any event, you get 750, which is what he needs. So there may be an argument that here, all you're doing is bringing forward when the claimant would have spent the 150,000, therefore do this simple single calculation. An acceleration case, I think these are as rare as hen's teeth, but somebody asked about them. We have those few cases where somebody needs a bungalow now, let's say at age 40, which they would have come to a bungalow at 75 in any event. Let's say it's an acceleration of a degenerative hip or orthopedic condition or problem, which means that they become increasingly disabled much earlier. If you do a swift calculation there, on that example, you get an award of 122,000. But the difficulty with that is, if the claimant spends the 122,000 he's got by way of damages, plus the 150,000, and plus sells reversionary interest, he's got, well, he owns that property outright, or a very substantial proportion of it, but he would have always spent the 300,000 in any event. I just wonder whether here, all you're talking about is the timing of when the claimant spends money he would have spent in any event, and query whether Swift and Carpenter applies, or the model applies. Query whether this is a circumstance where we have to consider, one, what the nature of the loss is, but two, once you know what the loss is, how is it to be compensated, and does Swift work? Betterment. This is something that a lot of people have asked about and got very interested in. Query whether the time or effort is really worth it. I used B for the but for property. So in my formula, I need a new letter for betterment, and I've used I for improvement. But let's imagine this situation. The claimant needs a £750,000 house. He owns a £150,000 house, so that's the but for property. He's going to get the cost, let's say it's 200,000 for the adaptations. And once those adaptations are completed, it will increase the value of the property by £50,000. How and where does that betterment feature in the calculation? If you don't bring it into account at all, then that's the first calculation. You just say 750 minus 150, you do the 1.05 to the minus 30, that's the life expectancy, to give you your reversionary interest value. You deduct it, and then it's 461,174. Okay. But if you were for a defendant, wouldn't you say, well, you've got the adaptation funds, you're going to adapt the property, which means you now have a property that's not worth 750,000, it's worth 800,000. And if you were to sell the reversionary interest with the betterment included, the value of that reversionary interest is higher, because you're selling the reversionary interest in a property which is worth more. If you bring betterment into account, and it seems to me that one should, then the calculation would be, well, the property is worth 750,000. Once the works are done, its value goes up by 50,000. So we add that on, because you're going to be selling the reversionary interest in the property that's worth more, but deduct what the claimant would have spent in any event, the 150. So rather than the value of the reversionary interest being based upon 600,000, it's based upon 650,000. And that produces a slightly higher reversionary interest value, the 150,395. You then deduct that from how much does the claimant need to spend. The claimant needs to spend 600,000. He doesn't need to spend 650. He's going to spend 600,000 to purchase this property. So it's 600,000 less the reversionary interest of 150,395 gives you an award of 449,605. The difference between the two calculations is only £12,000. And in these cases where the valuations sway by hundreds of thousands of pounds on particular points, something that has an impact of £12,000, even with these sorts of property prices, query whether we're going to end up arguing or haggling over where betterment features. But that's the impact that it has, and it seems to me that's how you reflect betterment. What you don't do which we used to do, is then go on and deduct the betterment, the actual 50,000, which we used to deduct from the adaptation costs. That's because the claimant isn't going to get his or her hands on that money. They're not going to benefit from it. The next one is renters. This is potentially significant. The question is, if somebody would have been a lifetime renter of a property, they wouldn't have actually purchased a property. Do you give credit for what they would have spent on rent, and where does it feature in the calculation? First point, undoubtedly, you have to give credit for what they would have spent on rent. That would have been their cost of their but-for cost of meeting their accommodation needs. So it has to be brought into account at some stage. The question is, do you include it in the SWIFT calculation as the but-for property cost, or do you leave it out of account when you're doing the SWIFT calculation, but then deduct it as a separate second step? Now, bearing in mind that I act for claimants and defendants, I will tread carefully in terms of the view I express about this. If you include it in the actual SWIFT calculation and say, well, what would the claimant have spent on rent as a lump sum across his lifetime, and include that as the but-for property costs, you produce a higher figure than deducting rent as a second step. In our illustration, you could see if you took that approach, you would have an award of 96,000 odd. Whereas if you did the SWIFT calculation saying the claimant would have invested nothing in property in terms of investing in and owning a property asset, and then but deduct the rent, once you've worked out your SWIFT figure, then you get a much lower award. On those modest numbers, it's a difference of over 50,000. My thinking at the moment is that there is an argument that the second of the two is the better approach, because if you include the rent as the but-for property spend, you're not comparing like with like. If somebody spends £224,000 on purchasing a property, then they've purchased an asset which they are then able to leave to their estate or do whatever they want with. And therefore, if you give credit in the SWIFT calculation, you are saying that the estate would have received that bit in any event. If you rent something, a property, you're not investing in an asset. There's nothing that you will own as a property that you can leave to your estate. When you die, your tenancy will end, and that is the end of it. That's why it seems to me that you calculate the SWIFT award on the basis that the claimant would have made no investment in property, which would mean the entire, or the value of the reversionary interest in the entire property would be sold, because there is nothing that should be ring-fenced to pass to the estate. The estate would never have received ownership of a but-for property, because there wouldn't have been one. You do the calculation, the SWIFT calculation, on a conventional basis with a zero but-for property value, but then once you've worked out that figure, as a separate second step, you deduct the rent, and that gives you a value of 44,666. That may have to be argued, but at the moment it seems to me cautiously that is conceptually a better approach. I'll deal with this quickly because I'm conscious of time. Somebody raised a question in another seminar. What happens if somebody buys a property at a point where it's believed that their life expectancy was 40 years, but they died after 5 years before the date of trial? How do you value it? It seems to me, and if you use 40 years versus 5 years, you can see you get very, very different outcomes. An award, if it was based on 40 years, would be much, much higher than if it was based upon 5 years. If you were buying a reversionary interest, but were going to get your hands on it, on the asset 5 years later, you would spend a lot more than if you were going to wait 40 years. It seems to me that you would use the 5 years. The court can't ignore or assume a fact which it knows to be wrong. You can't put 40 years into a calculation of life expectancy when you know with 100% certainty the claimant's life expectancy was 5 years. So it seems to me that you would use the 5 years in the calculation, not the erroneous 40 years, which it had previously been thought it would be. But again, vanishingly rare, sort of question that some painful barrister asks if they're trying to catch you out. But those are some worked examples. And as I said at the beginning, Kelly will send you the slides. If I just look at the future, what are the implications from the judgment? First of all, short life expectancy cases. Roberts and Johnston no longer applies. Doesn't apply to long life, and it doesn't apply to short life. The Court of Appeal make it clear that they have not held that the SWIFT model applies to short life expectancy where there may be different considerations. That means that we have, to an extent, a vacuum in terms of what is the approach for short life expectancy cases. When you read the judgment, the direction of travel is that the default position would be full capital cost unless somebody can find an alternative, a workable alternative that provides fair and reasonable compensation. So that's the overview. In terms of what is a short life expectancy, everybody will want some sort of hard-edged, bright line numerical distinction. Let's say 10 years, anything above is a longer life, SWIFT applies. Anything below is a short life and SWIFT doesn't apply. For my part, I don't think that works. I don't see how you can say at 9.5 years, you're having a very different approach to somebody who's got a life expectancy of 10.25 years. When you look at the judgment, what becomes clear is the Court of Appeal is, in short life expectancy cases, concerned about and interested in the shortfall. If you think about it, the greater the value of the reversionary interest, the more credit the claimant has to give for that, the greater the difference between what he or she needs and what they're awarded. And what you have to look at is, what's the shortfall? What is the capital hole that the claimant has to fill to replace the value of the reversionary interest? They might be able to sell it, but experience will only tell. The bigger that shortfall, the more difficult it is for the claimant to make up that extra money, the more likely you are to be a short life expectancy case where SWIFT doesn't apply. And I think we're going to be looking at two things there. One, what's the amount in cash terms? The bigger the shortfall, the less likely it is that SWIFT is producing a fair and reasonable award. But the other point is, you've got to put that into context. What percentage is it of the overall award? If somebody has a £300,000 shortfall in a £10 million award, in rough and ready terms, I think isn't that 3%? If you had a £300,000 shortfall in a £1 million case, that's 30% of your award. That's a very, very different context. So I think it is, how big is the shortfall and how big a hole is it? How much will it take from the overall award for the claimant to top up or fill that gap? The bigger the gap, the bigger the impact, the more likely you are to be a short life expectancy where you'll depart from the SWIFT methodology. Point number two is this question of robbing from Peter to pay Paul. I think for anybody with a significant claimant practice, you will always explain that the overall award is never what's claimed, and there will always be a degree of cutting your cloth or borrowing from Peter to pay Paul. But it's an issue of principle in SWIFT. Is it legitimate to expect a claimant to take damages from one head of loss to make up a shortfall in another? Stephen Irwin at para 144 says not. It's wrong to expect or require a claimant to do that. And Nicola Davis, LJ, agreed with him. Nicholas Underhill on this issue said he wasn't convinced that was wrong as a point of principle, and in any event in Roberts and Johnston it was held that that was legitimate to expect the claimant to do it. I think that's going to become potentially an important issue, particularly where we're looking at short life expectancy. Is it legitimate at all, or to what extent is it legitimate to expect a claimant to make up the gap in order to fund the purchase? And if that involves drawing on other disability related awards, is that something that's allowed at all? Departing from Swift and Carpenter, there are 4 areas where we potentially can depart. One, if there is major economic change, if we're no longer in a negative or low positive discount rate era, by definition, it will be open to the courts to revisit the methodology. 2, short life expectancy, that's recognised in the judgment. 3, circumstances in a particular case, perhaps with unusual or novel circumstances, does the Swift approach provide a fair and reasonable award? If not, query the scope to look for an alternative. And 4, if the market it develops and shows that the 5% is too high or too low, the rate is capable of being revisited if there is an abundance of evidence that shows it's significantly too high or too low. For my part, those gateways, bar short life expectancy, are going to be difficult to get through. The hurdles you will have to get over to depart from Swift are going to be considerable. Interim payments, claimants will now include the Swift and Carpenter valuation in their EAL stage 1. I can't see any reason why it doesn't fall in EAL stage 1. There's nothing that would take it outside of that or as a discretionary addition at EAL stage 2. Point number 5, perspective. There's been a lot of noise about Swift and Carpenter. One, because Roberts and Johnston has been brewing for a fight for some time, and the numbers in Charlotte Swift's case are very high because of the London market. But we were settling our cases when Swift and Carpenter was going on, and there was all of that uncertainty. There are going to be wrinkles in the approach that we have to iron out, but I don't see myself a wave of stalling settlement meetings or trials or cases exploding in terms of costs or complication just because we've now got this new approach. I think we have to have some perspective. Accommodation is one significant but not disproportionately important part of our cases. And then finally, the implications of the finding that Roberts and Johnston was guidance and not legal principle. Somebody has said in a webinar that they wonder whether this heralds, I think the quote was, a new wave of judicial activism where how we have conventionally valued personal injury damages is going to be ripped up and revisited. For my part, I think that is alarmist. Roberts and Johnston was rightly revisited because it no longer provided fair and reasonable compensation, with numbers in every case which are very significant, and the huge importance of the property purchase to the futures for catastrophic injured people. Tinkering around with a Housecroft and Burnett 25% or the Coward and Comex assumption about fatals dependency rates is nothing on the same scale or significance. And personally, I don't see a wave of PI cases where people are looking to have root and branch reform of how we deal with all of our other major heads of loss. So that's my talk. I am conscious that my time estimate was poor and I've run over the hour. I'm going to stop sharing the slides and have a look at the Q&A facility to see if anybody's asked any questions. Assuming this is working, it says I've got no questions, no answered questions, no dismissed questions, no open questions. If anybody has got any questions for me, now's the time to ask them. No? Right. Well, I'll just pop up my, oh, here we are. Here's a question. Oh, it's a comment. Thank you from Rika. You're welcome. There's my email address. As I said at the beginning, Kelly will send you a recording of today's webinar. She'll also send you my slides. I'm conscious that there's been an avalanche of information and analysis. Hopefully a lot of it or all of it's gone in. If you've got any questions, feel free to email me direct, or whether you want to go through the clerks at Farrers, that's up to you. Thank you for attending today. Thank you for watching. And I don't know when the next Farrers webinar is in the series. Whenever it is and whatever it is, I'm sure it'll be worth watching. So we'll see you then. Oh.